All right, well, welcome back from lunch, everybody. Looking forward to this next part of the symposium. So I am very pleased to be introducing this debate between Professor John Leshy and Ethan Blevins on the constitutional foundation for America's public land system. Professor Leshy is the former solicitor of the Department of the Interior, a position he held for 8 years under President Clinton. He's also professor emeritus at the University of California College of Law in San Francisco. And he's written extensively about the property clause and the constitutional foundation for the public land system in the United States. Professor Leshy, thank you also for delivering the Ruth Wright lecture last night. What a fascinating conversation that was. Ethan Blevins is a senior legal fellow with the Pacific Legal Foundation who focuses on constitutional scholarship. Ethan clerked on the Fifth Circuit of Appeals for Judge Don Willett and received his JD and LLM from Duke. He lives in Utah, and he also authored an amicus brief in support of Utah's Supreme Court case in 2024. Ethan, thank you so much for joining us. So here's how the debate is going to work. Each of our speakers is going to get 10 minutes to present their views on how the Constitution is and should be applied to the management of federal public lands, with the focus, of course, on the property clause. We're going to let Professor Leshy go first. And then after that, each speaker will get 3 minutes for a rebuttal. And then after those remarks, we should hopefully have about 30 minutes left. And I hope that we can engage all of you in an interesting conversation with the rest of our time. So I'll likely lead us out with a couple of questions, and then we'll take questions from the audience using the Slido tool. So again, please use Slido. It's been going well so far, and it really helps. So with that, let's jump into the conversation about what truly is maybe the foundation for America's public land system. And we may have taken this foundation for granted for quite a while, but with Utah's recent foray in the Supreme Court, that's put this issue back on the radar and has reignited some debate. So we're really looking forward to this conversation today. And so with that, I will turn it over to Professor Leshy.
Thank you. You can put up a slide.
Yes, and we have some slides.
I just got 2, don't worry. And they're a little heavy on the text, but I'll walk through them. I'm really glad that we're having this debate. I'm glad, Chris, for the invitation and Ethan for participating. I think it's a lively issue. Utah's triggered this most recent discussion, and I'm glad they have, because it's a really interesting topic, not just because I've written about it, but because I think it's, you know, the public lands are an obscure part of American society, and the property clause of the Constitution, which is the essential constitutional provision, is even more obscure part of American society, American law, and the Constitution, not often looked at. So I'm going to lay out in my opening remarks just the essential case for why the public lands are constitutional, are fully consistent with the Constitution. And it goes like this. This is the property clause in its entirety, Article 4, Section 3. And the key parts are, at least the way I read it, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory and other property of the United States. That seems pretty straightforward to me. One thing to note, because this becomes part of the constitutional debate, is what does dispose mean? Because to some lay people, dispose means to get rid of, like you toss something in the trash. But if you fully consider the word dispose, including what it was understood to mean in the 1780s when the Constitution was drafted, and by this you rely on Samuel Johnson's Dictionary of the English Language, which was the source for English meaning in that era. It includes many things besides getting rid of. It includes things to regulate, to place in any condition, to apply to any person. So it is wrong to textually read the property clause as saying this authorizes Congress simply to get rid of public lands. It does not. It authorizes the Congress, as I read it, and as I think the text supports it, authorizes the Congress to decide what to do with the public lands, to manage them, to regulate them, to place in some condition, to apply to any purpose. It has a broad meaning. And second point here, the Congress has many times used those words, dispose of, in statutes relating to public lands over the last 240 years, 230 years, as basically applying those many meanings. So it's never, Congress has never exclusively used the word dispose in statutes applying to public lands to mean get rid of or dispose of, transfer out of federal ownership. So that's really important to understand. And once you appreciate that the word dispose has that open-ended meaning and that Congress has applied it that way, then you go back to the property clause and it becomes clear, at least to me, that the Congress shall have the power to do, frankly, whatever it wants to, whatever it decides to do through the congressional political process, to do with public lands, which incidentally means public lands have no constitutional permanence in the sense that Congress can decide to get rid of all of them by a statute, simple statute, enacted tomorrow, if Congress had the political will to do it. But the essential bottom line point here is that the Congress has plenary, as the law, we lawyers say, meaning full and complete power to decide what to do with public lands, whether to hold them, whether to get rid of them, whether to partially transfer them, whether to protect them fully, whether to exploit them, et cetera, et cetera. These are political questions subject to the political process as spelled out, as I see it, quite clearly and plainly in the Constitution. So the text of the Constitution supports it. Congressional behavior implementing that text supports it. And then next slide, last slide, a little bit more text, not too much. And the US Supreme Court has basically agreed fully with that in decisions since the Civil War. So there has not been a Supreme Court, US Supreme Court decision since the Civil War that has said anything other in interpreting the property clause, that has said anything other than the property clause gives Congress power over public lands without limitations. That is a quote from a unanimous Supreme Court decision, several unanimous Supreme Court decisions, including one as late as 1976, Kleppe versus New Mexico. All 9 justices said, yeah, we've said this before. Property clause means Congress has complete power over the public lands, and their disposal in any way must be left to the discretion of Congress, and a state has no right to claim public lands within their limits, no constitutional right. So the court has reaffirmed that in more than a dozen decisions since the Civil War. Now, I say this since the Civil War, and this is an interesting and important point, because there are 2 pre-Civil War decisions which actually suggest that there are some limitations on Congress's power in the property clause with regard to public lands. Both of those decisions, the way I read them and look at them in context, were inspired by slavery, were inspired by the court's zeal to defend the institution of slavery. In the most famous case to that effect is Dred Scott. Dred Scott versus Sanford, where the court said a lot of terrible things about African Americans, but it also said Congress has no power under the property clause to outlaw slavery in the territories of the United States. The court said that in Dred Scott, even though Congress had several times, beginning in 1790, I think, had outlawed slavery in territories. So the court in Dred Scott went against that history and that precedent. And it's widely regarded, and I think almost any lawyer would tell you this, Dred Scott is widely regarded as the absolute worst decision in the United States Supreme Court history. And it precipitated the Civil War because it took slavery and how to deal with slavery out of the political process in terms of public lands. So I underline that because of the sort of sordid history of Dred Scott, and most people should probably say, oh, it said something about the property clause. In fact, it did. It invented a theory of the property clause that the court has never followed since. Never had really followed before, and has never followed since. So nobody cites Dred Scott in the Supreme Court anymore. It is considered so embarrassing a decision on all grounds that you just kind of don't do it. When I worked for the Interior Department, I remember we had some case involving something public lands, and one of the attorneys had drafted a brief to send over to justice, and his supervising attorney came to me and said, "I'm not sure we should send this brief over here." I said, "Why not?" He said, "Because it cites Dred Scott." I said, "What?" I said, "Nobody cites Dred Scott. Take that out. You cannot cite the Dred Scott decision." So we took it out. Okay, that's the opening case, and thank you very much.
I feel like I should open with a caveat that I do not like Dred Scott either.
Good.
I'm very grateful to be here with Professor Leshy, and thanks to Professor Winter and all of you. I suspect that I have been invited because there are so few reputable scholars willing to make the argument that I'm going to make to you today, which is that the public land system in its current form largely violates the Constitution's separation of powers. Now, indulge me for a moment in a thought experiment. Imagine you go to the Rocky Mountain National Park not far from here over spring break for a week of camping. On a hike with your friend teases a nesting bird. Well, it so happens that it is a federal crime to tease a nesting bird on our public lands. Not because Congress has adopted a law to that effect, but because a federal bureaucrat in our land agencies has decided it's a federal crime to tease a nesting bird. That evening, you rustle together some grub, you push a couple of your campsite tables together so you can sit with each other. You have committed your second federal crime of the week, which is moving a fixture on a campsite on public land. Not because a bill went through the bicameral legislative process and was presented to the president, but because a federal land agency decided it should be a crime to move a fixture on a campsite on public land. Finally, at the end of your crime spree of a week, you decide to all hold a foot race on public lands, and you have thus committed your third federal crime, because it is a federal crime to hold a foot race on public lands, not because a legislature passed a law to that effect, but because someone buried somewhere deep in the labyrinthine recesses of the administrative state decided that that should be a crime. So now you're a regular Butch Cassidy roving the West, committing crimes, driving on public lands with a tail light out, or putting too much wood on your campfire. There is a crime that the federal bureaucracy has created for you. Now, I do not think it is the proper role of the federal government to exercise what amounts to a federal police power over a quarter of the United States landmass, 640 million acres of land owned by the federal government. And this is not just a turf war between the federal government and the states. It's ultimately about individual liberty, because the separation of powers protects individual liberty by preventing the abuse of power that occurs when power pools into one place, which is happening with respect to the public land system. Why? Because the separation of powers is violated along two dimensions by the current public land system. One, between the federal government and the state governments. That separation is cobbled together by our public land system so that the federal government's exercising powers reserved to the states. And second, it causes this delegation of lawmaking authority and therefore violates the separation of powers between the federal branches themselves, primarily the legislative and the executive branch. Now, to touch on the federal-state balance first, it is the crux of the Constitution and its entire design that the federal government is a government of limited powers, that any power that is not expressly enumerated in that document is reserved to the states. That's the 10th Amendment, but it's also the entire design of the constitutional structure. It strikes me as strange, therefore, that the federal government, with no limitation on how much land it can own, can exercise what amounts to unenumerated federal police power on all of that land without limitation. Professor Leshy is absolutely correct. The Supreme Court said that, and I'll try to address that probably in rebuttal. But it violates this fundamental constitutional tenet that we have a federal government of limited power and the rest is reserved to the states. Now, the primary justification for this boundless federal police power is the property clause. But looking at the history, the context of the Constitution, and the text itself does not support the broad reading that has been given to it by public land advocates. First of all, the history of the property clause indicates its very narrow purpose. 1780, the Continental Congress makes a promise by resolution that Western territories owned by a certain number of the colonies, Virginia foremost among them, would be ceded to the new United States government and then sold. That was the promise made by the Continental Congress as a condition. Some colonies did not want to enter into the Union with those Western territories still held by other colonies. The problem was, under the Articles of Confederation, that Congress could not fulfill that promise because it lacked a disposal authority, because very quaintly back then they cared about the powers that were granted to it and did not exercise powers that were not given to it. So the Constitutional Convention comes along, and their entire purpose is to fix the deficiencies of the Articles of Confederation. And the property clause is an easy one. We promised to get rid of this land, and we haven't because we didn't have the power to do it. Let's grant Congress the power to dispose of this property. It sailed through the convention with almost no debate or controversy. Now, if it meant that the Constitution could slip the shackles of its enumerated powers that they had worked so hard to define, I think it would have engendered at least a little bit of controversy. It didn't, because they understood it simply to mean Congress can dispose of this property. It has the power to do so. The broader context of the Constitution supports this, because it turns out the property clause is not the only clause that grants the federal government power to own and exercise authority over property in the states. There's also another thing called the Enclaves Clause in Article 1 that says, Congress, if you want to own and exercise jurisdiction over property in a state, you have to get the state's consent, and you can only use that property for, quote, needful buildings. Well, as it turns out, of the 640 million acres of property owned by the federal government, very few of that's used for needful buildings, and it's certainly not at the consent of the states. So why would we have this very narrow Enclaves Clause if the property clause allows the federal government to own whatever property it wishes without state consent and use it for whatever purpose it deems necessary? And finally, the text itself supports a narrow reading of the property clause. To address briefly the word dispose, I agree with Professor Leshy that it can mean different things, but I think that begs the question of what it meant in this instance. And there are many clues in legal documents of the time period that indicate that the property clause meant sale when it used the word dispose, to get rid of. So for example, the Land Ordinance of 1785 was created to define how properties held by the territories are supposed to be sold. It's very clear that it was all about sale. And it is called, quote, an ordinance for ascertaining the mode of disposing of land in the Western Territory. Later in the Northwest Ordinance of 1787, which is very relevant to how these territories are supposed to be governed and dealt with, it said, quote, that the states shall never interfere with the primary disposal of the soil by the United States and Congress assembled, nor with any regulations Congress may find necessary for securing the title in such soil to the bona fide purchasers. In other words, what the Northwest Ordinance was contemplating when it said the word disposal was securing titled bona fide purchasers, the sale of the land. And in fact, that language in the ordinance is also directly relevant to the needful rules and regulations component of the property clause. So there are two sections of the clause. There's a power to dispose and there's a power to adopt needful rules and regulations. What does that mean? Well, the Northwest Ordinance says that Congress may find it necessary for regulations Congress may find necessary for securing the title in such soil to the bona fide purchasers. In other words, Congress can adopt needful rules and regulations for the exercise of its disposal authority, not for the exercise of some boundless unenumerated authority. So it has the power to adopt regulation. Regulation in the late 1700s did not mean substantive law like the exercise of police power. It meant creating an orderly process, to make orderly, to make regular. And that's the power Congress was granted, to create an orderly process for the exercise of the disposal authority the property clause granted it. Thus, the property clause did not allow the federal government to escape its very limited enumerated powers. It can't slip its shackles just because it happens to own land. Now, the other problem that I want to briefly address is non-delegation. As I alluded to in our opening thought experiment, Congress is not the lawmaker on 640 million acres of land in the United States. The federal land agencies are. And FLPMA, the Federal Land Policy Management Act, gives virtually boundless discretion to the Interior Department and other land agencies to adopt whatever regulations they deem necessary for the management of that land. In other words, the lawmaker on these lands is the federal bureaucracy in contrast to the very careful vesting of the legislative power in Congress alone. And this non-delegation problem is actually a live issue. A case called Pheasant versus the United States, Nevada District Court agreed with me, but the Ninth Circuit reversed. So that is a live issue today, but I do have to say that you have nothing to fear from me. I am a libertarian scholar and therefore completely harmless. No court in the country is going to ever adopt the argument I've made today and upturn our public land system. So don't worry, it is the curse of a libertarian to always be right and never be able to do anything about it. But I hope that some recognition of the fundamental constitutional principles at issue here will lead to management of our federal lands in a way that better respects the separation of powers and the individual rights that that separation protects. Thank you.
Okay, thank you, Ethan. Couple of quick points in rebuttal. One is Ethan quoted the 10th Amendment as saying all powers not expressly enumerated in this Constitution for the federal government are reserved for the states. Again, as I explained in my opening remarks, I can't think of anything more expressly enumerated in the Constitution than the Property Clause, which says Congress shall have the power to dispose and make all needful rules and regulations regarding the territory and other property of the United States. Second point, and the really important point here, is to understand the institutional context. What Ethan is saying, basically, is that for the last 140 years, we have operated under a public land system of policymaking where Congress makes the decisions through the inclusive process, deliberation. We vote for them, they decide what we want, and it's a democratic process. What Ethan is proposing to do is to transfer that power, the ultimate power over decision-making about the public lands, from the democratic process of who we elect and what they do when we send them to Washington to make these decisions, from them to 5 unelected justices sitting in Washington, D.C. They would make the public land laws. They would decide what the public lands look like. Personally, I am terribly uncomfortable with the prospect that we have these 5 unelected justices totally removed from the political process, answerable to nobody, making these decisions. And I think the experience in the United States for the last 140 years has been that system that we have, that democratic system of policymaking about public lands, has worked extremely well, because when you look at public opinion polls, do people like the public lands? Are they satisfied with them? The answer is overwhelmingly yes. And so what he's proposing is, let's take that power away and give it to those 5 guys in Washington, four guys and 1 woman in Washington, D.C. to make these decisions. One last point, and that is the argument here, and the argument that Utah makes on the property clause puts them in a terribly uncomfortable position, because the net effect of their argument is that the national parks, among all the other public lands, are unconstitutional. Now, Utah is terribly uncomfortable saying its national parks are unconstitutional because, among other things, the Utah Division of Tourism has for the last 25 years been touting in nationwide ad campaigns, come visit our mighty 5 national parks. They've actually trademarked that slogan. And so what does Utah say in the Supreme Court, or in its argument about the national parks? They came up with this totally muddled theory that says, well, the national parks are okay, even though they're not needful buildings or anything like that under the Enclave Clause, but they're okay. And they have some muddled theory about national parks are appropriated public lands, and all the other public lands are not appropriated. There's nothing in the Constitution about appropriation or unappropriated lands or all of that. So I think the national parks being unconstitutional box is a really powerful illustration of the shortcomings and frankly the bankruptcy of the property clause, Utah's property clause argument. Thank you.
So I just want to address, among other things, Professor Leshy's argument about case law. He's right that there was a case in Kleppe versus New Mexico back in the 70s that said that basically this property clause authority is plenary and it's without limitation. This was actually a very narrow issue about whether certain state laws regarding wildlife can be enforced or not on public land. And so the without limitation language is dictum. It was completely unnecessary to holding the case. Another case that I think Professor Leshy had up on his slide, and this is the curse of every lawyer, which is that you see a case a million times, you read it a million times, you have no idea how to pronounce the name. So I do not know how to pronounce the name, but it's a Gratiot, something like that. Gratiot. There you go. And that case also used this without limitation language, also a very narrow issue, which is basically, is leasing a form of disposal or does it have to be sale? Now, right or wrong, the court said leasing is okay. We're okay with them leasing what was a lead mine in that case. And then it used this without limitation language. Again, pure dicta. It was really about the role of the federal government as a proprietor. And that's a fundamental distinction here. When the federal government owns property on its property clause authority, the courts have said it exists as a proprietor, not as a sovereign. When it owns property under the Article 1 Enclaves Clause, then it owns and operates that land as a sovereign. In fact, there is a post-Civil War case, contrary to what Professor Leshy was saying, that says just this, a case called Fort Leavenworth Railroad Company versus Lowe, and that case was about whether a state could tax a railroad line that ran through federal property, and the United States Supreme Court said yes, because when the federal government owns property through the property clause, not the Enclaves Clause, that it has, quote, only the rights of an ordinary proprietor, end quote. In other words, the rules and regulations that adopts that are needful are those that could be exercised by any regular proprietor, preparing it for sale, and so forth, leasing it. These are the things we expect a proprietor to do, any landowner. To exercise a police power over it is an entirely separate issue. That's why we have the Article 1 Enclaves Clause. To just also address Professor, I actually agree a little bit on Utah's distinction that it's trying to make. It is a difficult distinction, but what I think they're trying to say is that there's a difference between the use of the land that's necessary and proper to serve some enumerated purpose and the use of the land for any enumerated purpose. Right? We have this necessary and proper clause that recognizes some flexibility that Congress has in fulfilling its enumerated powers. But it doesn't have any unenumerated authority to do what it wants. And I think the distinction trying to be made here is when the land is dedicated to some federal purpose, fulfilling some enumerated power. Now we could argue whether a national park fulfills an enumerated power or not. That's a real question. But assuming it does, it's dedicated to that purpose. BLM land, meanwhile, can be used for literally anything. Multiple use and sustainable yield, which means virtually any use that BLM decides to put it to. I think that's the distinction Utah is trying to make and is a little more defensible under this necessary and proper point. But thanks very much.
Okay, thank you both to Professor Leshy and Ethan for your opening and your rebuttals. Really appreciate it. I have a couple follow-up questions and we'll turn it over to audience questions as well. But I want to start on the separation of powers issue, which I think is a really interesting one, and maybe bring Utah's most recent foray in the Supreme Court more back squarely into the conversation today, because I think a lot of us are thinking about it. Utah attempted to get the Supreme Court to intervene in this dispute over whether the public land system was constitutional, and there were questions about the relief that Utah was asking for, and then the federal government filed its brief and didn't directly attack jurisdiction, but certainly said there's some jurisdictional problems here. We have serious concerns. This is something the lower court should sort out if this is going to move forward. And one of those concerns was a separation of power issue where the federal government was saying, listen, this is not something the court can do. This is something that's dedicated to Congress. This maybe gets back to Professor Leshy's original point, but I guess maybe starting with you, Ethan, how do you see the separation of powers issue that you raised in your opening applying to something like Utah's effort to have the Supreme Court weigh in this and, in a sense, order Congress to start passing laws that would then result in the disposition or divestiture of federal public land? So how does that separation of powers issue cut on that issue?
I agree that the Supreme Court could not properly require legislation unless there's some kind of mandamus order. You know, officer, you have a legal duty that you have to go fulfill. Then you're getting into political question world. I think the proper remedy would be to say that the Federal Land Policy Management Act's current status, which is a presumption in favor of retention. So it says, look, we're going to retain this land unless the Secretary of the Interior finds that it's in the national interest to dispose of it. That presumption in favor of retention is unconstitutional. And I think that's well within the court's role, right? To point to a provision of law and say this does not satisfy constitutional scrutiny. Then it goes back to Congress, like any law deemed unconstitutional. Then it goes back to the lawmakers to try to figure out how to make it constitutional. Now, of course, in the opinion, the court may give its views on what a constitutional way to manage the public lands would be. But I think them ordering directly, you have to create legislation that's going to dispose of this land, I agree, is problematic under the separation of powers.
Nothing to add to that, really. I think the issue is really pretty simple. Do you want the court, these unelected justices, muddling through this sort of complex set of issues, or do you want the political process to operate? Congress has made lots of laws about public lands and made lots of decisions about how the public lands should be managed and when they should be sold and why and under what conditions and all of that through the political process. And the courts have stayed really entirely away from that process for the last 140 years. And it's all operated great. There's no problem here to fix as far as I see. And the fix that is being proposed is terribly dangerous and could really come back to bite everybody all across the political spectrum. So that's where I come out.
Anything to follow up on that?
Not really. I will say, I think that one of the interesting challenges that Utah has, and I don't know if you're planning to stress this, is this enabling act that most states have, Ohio and onward, where they disclaim title to federal land. And this was brought up extensively. It's like, Utah, you've already disclaimed this, but that doesn't address the question of whether there's a duty to dispose. And I think that duty to dispose of the land still exists, even if Utah itself does not have a cognizable argument that the federal government has to cede the property to the state itself.
Okay, thanks. One more question, then we'll turn it over to some of the questions of the audience. But, I think a lot of us, when we saw this lawsuit from Utah, kind of scratched our heads and said, man, what is going to happen if Utah wins the case? So what happens at that point? And so I'd like your views on what it would look like if Utah's, or Ethan, if your theory were to prevail. So what would happen next? Because I think a lot of the conversation was the states want the land back. And so that was part of the framing of the arguments of what Utah was trying to do. And I think some of us were confused about what relief Utah wanted, but in real world terms, what would happen if Utah were to prevail in that argument? The public land system was declared to be unconstitutional in the way that you say, what happens next and how does that land get distributed or redistributed? And Professor Leshy, interested in your views as well as what would happen.
Okay.
All right. Well, again, because of the Enabling Act that Utah agreed to, I think what would not happen is that the property is simply ceded to the state. I think that what would happen is that Congress would have some obligation to start moving forward with a disposal process. That might sound terrifying, but in fact, since our founding through today, really, although it was happened at a much more rapid pace up through the 70s, federal government's been disposing of property that entire time, millions upon millions upon millions of acres. So I think that process would have to restart at least a slightly more rapid pace than what exists now, which is a presumption the land should be retained. Again, I think that's probably the main constitutional problem. I do think it's going to be a political question committed to Congress about the pace at which that occurs, how it occurs, who can be sold to. The property clause, I think, says, Congress, you adopt the needful rules and regulations for the disposal process. And that's, so the way disposal happens, I think, is constitutionally committed to Congress. Could Congress delay it inevitably? Maybe. This comes up in another context in which I write about, which is the takings clause, where we've brought cases and say, when do you have to provide just compensation for a taking? And the courts have said, before the plaintiff dies. So not very comforting, but again, that's the kind of thing the courts are gonna say, it's largely gonna be committed to hands of Congress.
So what is going to happen if Utah won this case? Frankly, I think it's anybody's guess as to what will happen. But what I do know is if the court says we have the power to decide what disposal means and what Congress's obligation with respect to the public lands are, is that it is going to be, those unelected justices are going to be hovering over those decisions all along from now till forever, I guess. And the essential power over how those public lands are handled, kept, retained, disposed of, sold, transferred, managed for what purposes, those are ultimately going to be decisions for those justices and not for the political process. I think it is a terrible wrong to take that out of the hands of the people electing representatives and putting it in the hands of those justices. And that's the big problem with this. Once you cross that threshold, once you say, no, the courts are going to decide what is appropriated or unappropriated and all of that, then they're a key part of the process that they haven't been for a long time. And so I think it'd be a terrible mistake. And, you know, one other point on that, Ethan made the point, well, you know, it's objectionable because Congress has given the executive a lot of power to decide about certain things. Well, if people don't like that, then they can change it by electing people to Congress who are going to take back that responsibility and have Congress make those decisions. So that's curable through the political process. What he's proposing and what Utah is arguing is not curable through the political process, other than over the long term putting new justices on the Supreme Court. So again, institutionally, I think it's a terrible step to transfer that power, which has resided and people have been happy with its exercise in the political process and putting it in the hands of the judiciary.
Can I just briefly respond? I think the democratic accountability question is a really important one. But I look at it a little bit differently. Currently, you know, a Massachusetts senator, New York senator has as much say, or really in a lot of respects, more say over what happens, for example, over 60% of the state of Utah. Utah is 60% federally owned, 80% of Nevada, 80% federally owned, then the state, certainly the state legislatures in those states, and the elected federal legislator in those states. They have very little political power to actually augment change that represents the constituents that they represent. Instead, you know, of course, the constituency in Massachusetts, New York want a nice place to go for vacations. They're not interested in the economic welfare of the state of Utah or Nevada. So I think there's a democratic accountability problem with allowing this to be federalized rather than a little bit more subject to local control.
If I can make one brief rebuttal to that, and it's a really important point that most people don't appreciate, and that is under our legislative system, and I used to work in the House committee and saw this operate time and again, Congress does not pass legislation with respect to a particular area of public lands over the objection of the representatives from that area, the senators and congressmen from that area. That happens over and over again. So not an acre of land in Utah, for example, gets designated as wilderness if the Utah delegation opposes it. That is a powerful custom that runs through Congress and has operated that way for 200 years. So to say that a representative from New York has more say about Utah public lands than the Utah representatives have is just flat wrong as a matter of fact and as a matter of congressional custom. So.
Anything else?
Or we can move on to questions.
So we have a couple questions about the Constitution itself and the structure of the Constitution, which I think are quite interesting. So the first is, what is the significance, if any, of the location of the property clause in Article 4 rather than Article 1, which is where we find Congress's enumerated powers? So to either of you, and then we'll let the other weigh in.
Good.
I'm so glad you asked. So Article 1 is where the legislative power is housed, right? Not Article 4. And I think it's telling that the property clause uses the word rules and regulations and not legislative power, not law, right? There's a reason why drafters use different language. And as interpreters of the language, it is our responsibility to render meaning to the different uses of words. And certainly regulations specifically, as I mentioned before, very different than something like a substantive law, at least as of the late 1700s when this was written. So I think there's a lot of significance to it, because I think what is not being given to Congress is the traditional legislative power. That's in Article 1. Article 4 is something different. I think it's more in lines of the power of a proprietor, as case law said, rather than as a sovereign lawmaker.
That's a classic kind of lawyer's, sort of structural argument. Oh, it's in Article 4 and therefore it's completely different. I don't know how you can read the text of the property clause. Congress shall have the power to dispose of and make all needful rules. That is a legislative power. That is an express grant of power to the Congress. And it's in Article 4, not Article 1. So I think the whole idea that Article 4 somehow makes that power different is just wrong. And frankly, the Supreme Court has said in many different decisions over the last 200 years that the location of a power in the Constitution, which article it appears in, is really pretty irrelevant to how you think about that power. And I think that's exactly right.
Anything else to add on that?
I confess to being guilty of sneaky lawyering, absolutely. but I do think, these are like standard canons of construction. It's looking at structure. All these things are well accepted tools that lawyers and judges use. So I think it is relevant.
And in those many post-Civil War decisions where the Supreme Court has said the power of Congress over property is without limitations, they have made no reference to the fact that that power resides in Article 4 as opposed to Article 1.
So we have another question focused on the kind of the structure of the Constitution. I think maybe, Ethan, this gets back to your earlier comment about, the dichotomy between Utah's position on respect to its interpretation of the property clause, and then it's saying in this case against the federal government, the Supreme Court, that, well, Congress can reserve parks and designate parks. And so I think the question is, would you say your reading of the property clause operates to the exclusion of an independent Commerce Clause authority to establish parks? But I think maybe also what that person is getting at is, what is the enumerated power that Utah was relying on when it was saying it's okay for Congress to establish parks and wilderness areas and monuments where that's happened? And we're not challenging those, we're just challenging the unappropriated federal lands. So is there an enumerated power? Is it the Commerce Clause? Is there some other enumerated power which serves as the proper foundation for Utah's argument on that point?
Well, they don't name one. Now, the person who wrote this petition is Paul Clement, who's no slouch. But granted, I think there's some pragmatism here, absolutely. They don't, if they're telling the courts the entire national park system needs to go down in flames, that's guaranteed not to get the petition granted. But I don't think it's a crazy argument. I don't think they want to go in the direction of having to specify what enumerated power allows the federal government to own and operate a national park. I think there's probably a Commerce Clause argument to be made that there's tourism, cross-state tourism, and things like that. Now, whether you need to own the land to regulate that kind of commerce, whether it's necessary and proper, to the fulfillment of that power, is an open question. But I think probably the best argument is to say, we regulate foreign and interstate commerce, and look, there's tourists coming from all kinds of states to this park, we can regulate it. That's probably the best argument.
And so there's tourism that comes from all over the country to go to BLM lands, okay? The Commerce Clause argument is no different as applied to BLM lands as applied to parks or anything else. So I think this kind of agonizing scrambling to look for a way to make the parks survive this kind of constitutional argument really underscores the bankruptcy of the argument. And, Congress has passed, speaking of appropriated public lands, Congress passed a long statute with a huge amount of detail specifying what BLM can do and how it can manage those lands and for what purposes and through what process and all of that in the Federal Land Policy and Management Act in 1976, which went through overwhelming bipartisan support in the Congress. And nobody in that entire, I believe I'm correct in saying this, nobody in that entire legislative history raised the constitutional question. We don't have the power to do this under the property clause. I mean, this was not an issue because everybody assumed that that was well within Congress's power. So.
Would you like to respond to that? Because that was one of my follow-up questions is, in 1976, we got FLTMA. It was the retention policy for the unappropriated federal lands. Since that time, we've had oil and gas leases, we've had land exchanges, we've had, all kinds of other types of transactions that have resulted from that fundamental decision. So, what should we make of the fact that it's been 50 years and now suddenly we see a foray into the Supreme Court seeking to declare FLTMA unconstitutional after this long history? And so I just wonder if you could speak to that.
Yeah, it's a great question. I think there's a little bit of a Baptist and bootlegger element here going on where the states for various reasons like this, whether it's constitutional or not. Now Utah is taking umbrage with it. Of course, that is their prerogative to do so. But it is not always, Utah was not the first. I think it was 1979, the state of Nevada tried to pass a law to say these are our lands. You can't own 80% and exercise jurisdiction over 80% of our land. So it hasn't gone without problems. The Sagebrush Rebellion of the 70s and early 80s was part of that. And it had some political momentum because I think it was Ronald Reagan when he was running for office said, I'm a sagebrush rebel. So apparently there was some political capital to be gained to claim that. So I think it is a little bit more controversial than we sometimes realize, but also I do think irrespective of whether the states like it or not, this goes back to, I think there's a Baptist bootlegger problem with regard to Congress delegating its power. Congress loves to delegate its power. It doesn't have to take accountability for all kinds of things, but that doesn't mean that it can delegate its power. I think it's a similar dynamic going on here.
Raising the Sagebrush Rebellion and the Nevada argument back in 1979, 1980 raises an interesting point. I worked in the Carter administration in the Interior Department then, and what Utah has recently done was the same thing that Nevada and some other Western states did back then, which is to make a political gesture. They were unhappy with the federal lands, and so we're going to claim them. We're going to make this a constitutional argument that we own them, et cetera, et cetera. When Nevada passed that law in 1979, that formally claimed, as a law that the governor signed, formally claimed ownership of federal lands. We were sitting in the solicitor's office in Washington, and the Nevada Attorney General called up and said, we want to come back and talk to you about this law we recently passed. And we said, great, yeah, I'd love to discuss it with you, and set up the meeting. And we figured they'd come in and want to talk about an orderly way to litigate the case, that we made this claim, now we want to figure out how the best way to litigate it is, that they would talk to us about that. We had the meeting. I'm not disclosing any confidences here, I think. The Attorney General of Nevada walked in, and he only wanted to talk about one thing. And the one thing he wanted to talk about was he wanted our assurance on behalf of the Interior Department that the fact that they had passed this law making this claim would not interrupt the United States' writing of checks to Utah for payments in lieu of taxes, which was premised on the idea that the U.S. owned those lands. And they just wanted the dollars to continue to flow. And that's all they wanted out of this meeting. And they never filed a lawsuit seeking to vindicate that claim. It was just politics and a political gesture. And the same thing is going on here, except the risk is you are putting in front of these unelected justices the opportunity to make a power grab. And that bothers me tremendously.
So I want to bring the Supreme Court back into the conversation just a little bit, and there's a couple of questions that maybe touch on this, but the Supreme Court hasn't been exactly kind to the federal administrative state in the last couple of years We've seen Loper-Bright overturning of the Chevron doctrine. We've seen the major questions doctrine. And the Supreme Court seems to be growing increasingly skeptical of the authority of federal agencies to perhaps stray beyond their delegations of authority from Congress. And so I guess maybe for Ethan, I'm curious about a couple things. So one, does that address the concern you expressed in your very opening about, the authority of these agencies, somewhat lawless agencies, to outlaw or impose criminal sanctions on these activities? So does that relate in any way to your point? And also, maybe, and this is a broader question, but what does that trend in the Supreme Court hold for the future of public lands moving forward?
Well, yeah, I think there's definitely several justices have signaled that they want to revise the non-delegation doctrine. They think it's inadequate. They definitely see broad delegations of authority as being suspect. I think the Federal Land Policy Management Act is a very broad delegation of authority. It simply says, and it's a large statute, but it also simply says, the Interior Secretary adopt whatever regulations you deem necessary for the management of the land and for executing this statute. That's really about it. Multiple use, also very broad. Of course, there's goals, there's policy goals in there, but I think that the court's becoming more skeptical about the idea of simply announcing the legislative goal is sufficient, because they think that the legislature should also be saying something about the means for achieving that goal, that's part of what it means to exercise the legislative power. I think that FLTMA's language is probably perfectly safe under the current existing intelligible principles test, which is very weak. But if it were to be adjusted by, it's unclear, but I think that there's probably a 5-4 vote for doing something to tweak the non-delegation doctrine, then I think it could be brought within the scope of Supreme Court review.
I think it's frankly unpredictable what the court would do with the delegation doctrine. I firmly disagree with the idea that FLTMA is an unconstitutional delegation. I don't know how you could read the detail in that statute and the detailed instructions that Congress gives to BLM about how to manage the public lands as a broad, unlawful, unlimited delegation of power. But, and this is the really essential point, even if the court said, yes, it is an unlawful delegation of power, that punts the ball back to Congress to make decisions. So it still has the ultimate authority. All the court is telling Congress is be more specific. The property clause argument is completely different, okay? Because the property clause argument says Congress can't cure this problem. The court will tell you what you can do on the public lands, or how public lands shall be held, if at all, et cetera. It will be a judicial decision, not curable by Congress. The court would have the final say, whereas the delegation doctrine still leaves Congress with the final say over what to do. And that's a huge difference. And that, again, underscores the huge danger implications of Utah's property clause argument.
So we're getting close to wrapping up. I want to give you both a couple minutes at the end to share any last thoughts, but I do also have a burning question in my mind, and I hate it when people ask me to predict the future as a lawyer, because I'm always wrong when I try to do that. But I do want to ask you both to predict the future a little bit, and Utah has retrenched a bit after the Supreme Court issued its one-line order denying their motion. But I'm wondering, what do you think is going to happen, and do you see any indication from the court and trying to read the tea leaves and what the justices have written on other issues that indicates that they might be open to considering the argument if it were to work its way back up through the federal court system? And so, you mentioned Paul Clement's a pretty heavy hitter, and I agree with you. And so I wonder whether, he had thought through what the next steps would be if this first four-way was unsuccessful as it was. And so what do you think is going to happen next?
Well, I will say what Professor Leshy said earlier, which is predicting this kind of thing is a dangerous game, but we have a new Attorney General. Then the Attorney General initially kind of initiated this. That might change things. It's also possible that Utah has gotten the political capital it wanted out of this, right? I don't think it's disingenuous, the claim they brought, but I think it is a political maneuver to some extent. And maybe they brought attention to the issue and are going to try to make some political hay of that before they decide whether or not they want to work up to the district courts. I think it's almost certain when they get up to the top, they're going to get denied again. Why? Just because of the various criteria for the Supreme Court granting a case. There's going to be no circuit split they can point to. There's going to be none of the typical criteria you see. It's relatively settled historically. This is our practice. The Supreme Court's just not going to be interested in touching that in my view. As I said, the view I'm presenting to you today is entirely harmless because nothing's likely to change on it. So I think it's very unlikely that there would actually be a grant ultimately. Whether or not Utah's going to do anything, I think it's probably unlikely we'll see another case.
I agree with that, actually, and I think I have no inside information. This is all speculation on my part, but I think Clement, Utah paid him lots of money to put an argument together, and they filed it in the Supreme Court. I think hoping to at least get 1 or 2 or 3 or maybe 4 justices to say, yeah, you got a case here worth hearing. I think they were looking for some positive indication from at least some of the justices on the court when they filed their case, and they got none. I mean, it was a unanimous without a dissent saying, no, that we're not going to hear this case. You can go to the district court if you want to, but we're not going to hear this case. I think that was a tremendous defeat. And so the question now for Utah in terms of its internal politics are, okay, are we going to spend millions and millions of more dollars to litigate this case starting in the district court going up to the Supreme Court with such a limited prospect of victory and getting no positive indications from the Supreme Court? So if I had to predict, I don't think we're going to see a case being filed, but trying to predict what the state of Utah is going to do is not my forte. So.
Okay, so Ethan, any last closing thoughts?
Well, I feel like I should rise a little bit more in defense of Paul Clement because I was a little lukewarm earlier. It's true, of course, that there is tourism on BLM land. The difference is how these statutes reserve the property and to what purpose. So, for example, on BLM land, there's much more broader discretion to use it for leasing and so forth. All these kinds of things have nothing to do with tourism, if that's the Commerce Clause hook. Whereas you could, I think, make a colorable argument that the national park's dedicated to a more narrow purpose that's more in line with this possible Commerce Clause hook. But ultimately, this is an argument that goes back to our very founding principles, which is, again, the federal government is not a government of unlimited, boundless authority, and it's surpassing strange to read the Property Clause, which, again, for various reasons, as this relatively narrow, humble beginning, as this font of boundless authority that overrides state authority. So sure, there's some concurrent jurisdiction over federal land, but the federal government can simply preempt that at will. And I just don't think that that's in line with the fundamental premise that the Constitution was created with the idea that we had a government of enumerated power and that the remainder was reserved to the states. So, thanks.
All right, one last point, and back to what were the founding fathers thinking when they put the Constitution together, okay? Well, what were they thinking when they wrote the Constitution? They put in that property clause, which textually to me could not be clear. Congress shall have the power. They didn't say anything about the Supreme Court having authority to interpret and apply the Constitution. There's nothing in the Constitution about judicial review and Supreme Court gets to have the final say about the Constitution. That's not in there. That's something the court did by itself in a power grab in 1803 in Marbury versus Madison. And so you've got this implied power of the court to review and this clear text in the Constitution regarding property giving Congress that power, and to say that that first trumps the second, excuse me for that verb, is wrong. It's just fundamentally wrong. So.
Okay, we're out of time. Please join me in thanking our wonderful speakers.
Thank you.
Thanks, John.
That was fun. Yeah. Anytime.